volumes are translating into value. And that actually speaks to clearly the health of the organization and the bottom line. And what that means is, as we make decisions, as we make investment decisions, we are not just looking at what gas or what oil we are producing. Those are quite important. What we now start focusing on as Renaissance is, where do we capture value across the chain?
True.
To process this molecule to get more value. So as lawyer advising the transaction, working with the business, the underlying support you are providing is not just bare legal support. You remain a business partner in that journey. And that's actually the key role the lawyers will play, and also where we add value in that situation.
Okay. Thank you, sir. Thank you, sir. I will go to Lenesik now. Lenesik, when I speak to you and we speak, and you tell me that you've practiced in London, you've practiced in Nigeria, former chairperson, Commonwealth lawyers, only woman to have ever done that. So I believe that you are packed with so much wisdom to actually speak on this issue I want to ask you. In your view, how do you think legal and commercial advisors can bridge the gap between
part of a business, whether you're in-house or an external advisor? You have to understand that your job is to make business happen. Provide solutions. That's what risk manage so that business happens. It's not about big grammar. You can see I'm using Dirty December. I am demystifying what we usually do. If you can say it in a sentence, please don't say it in 2 pages. Plain English. Trust me, it works. As an external advisor to business, my primary client is the general counsel, whose client is the business itself. And he's got to go and translate what I've said to him to his board. So I developed a traffic light system. Red.
Policy may sound very good on paper. Policy may sound very good on paper. Right.
Sorry. I know we were going to ask more questions, but can you just hold on to that thought, just in case we have people who want to ask questions, so they can ask now. Not that after you ask like 3 more questions, people will now start to ask questions. So do we have anyone? Anyone here? Does anyone want to ask a question? Okay, thank you.
Good afternoon. My name is Marianne Okereke, Senior Manager, Portfolio Legal and Corporate Affairs at TradeGrid. When we talk about investment confidence, are we only referring to large-scale investments by major operator, 2 major operators, or are we also creating the conditions for investment in SME infrastructure, aka independent marketers?
Answer first on that question because you gave a talk on that. Answer first on that question because you gave a talk on that. Mr. Equipment.
For the regulator.
The regulator will. Okay.
Good afternoon.
Okay.
Good afternoon. My name is Ijeze Ezana. I work in Nembe Exploration and Production Company Limited, Senior Legal Counsel, Head of Corporate at home. The asset is here, the parties are here. Maybe it's an operator, or maybe their financiers are there. All of them are in Nigeria. But when we have dispute, we want to go to London, to New York, to settle our disputes. And the forex we don't have, we bleed it to those places. Why can't we settle our disputes at home? Is it that we don't trust ourselves? Renaissance general legal advisor said, Nigeria is not short of professionals. And the Learned Sikh also noted that Nigerians are playing heavily in the mainstream sector of the industries.
Our panel, but policy didn't really come out very central. And this panel really looked at policy more, in my view. And as a result, I want to ask this question. You know, I don't know how many of us here may be aware of the misalignment in policies. When investors, foreign investors come in, do you know where they go to? It's here, direct. Because by law, that is our policy-making body. So my question to the panel is, how do we enhance synergy and harmonization of policy across the energy value chain? Because when you talk about energy, energy encompasses power, petroleum, gas. So I was glad to see another Nigerian coming back from the UK and also a solicitor in the UK. So thank you. I've got a sister back. So as I was saying, the second question asks, do we lack expertise in Nigeria to settle our conflict? We don't lack, but we lack sanctity to contract. We lack apolitical judicial decision making. Thank you.
So please, just take a minute with your question. Our time is up, and the panelists still have some things they would like to share with this room. Any other question? That's all.
We're out of time for questions, so those 3 questions will suffice.
Okay, so I think the first question, talking about investor confidence, is goes to Engineer Bazaka.
Semi-infrastructure,
At least there's something I can say about that. Fortunately, because the financial cost of the MDGIF is not so humongous, our projects are mostly medium-scale projects, 5 million scope gas plants, 10 million scope, not the humongous 200 million scope. So that tells you that there's a relationship, not only big projects that have been looked at. And what is confidence? Confidence is about repeatability. As long as you keep on doing it all the time, everybody believes and it works out. Thank you.
Thank you, Engineer Bazaka. Just to add to what he says, I also think that the fund also investing money into the sector signals some level of confidence to investors to also come into the sector. So Lenesik, I think the other question, will be answered by you. Thank you.
So I will go back to risk management again, because the ADR clause is part of the contract. And the decisions around which law governs your contract, which seat you go to, are made at that time. So when I first returned home, I began to push for Nigerian law to govern at the very least, because the assets are here, whatever it is you're dealing with is here. So can we just have Nigerian law? That was a big step forward. And that's become more or less the norm, because it's become, we recognize that it is, it makes sense to have Nigerian law. However, the seat, and I'm being perfectly honest as an advisor, risk manager for transactions. If I am the one advising, I will still keep my seat in London. And I'll tell you why. Because business does not want to sit in the courtroom. I want my dispute resolved ASAP if we have to go to the courts. And in Nigeria, justice is delayed, and therefore justice is denied. It's no matter that I know of, except you're going to the rural courts for family matters. Commercial matters that you can start and finish at trial court level in a year. And I'm a senior advocate of Nigeria. Business doesn't like that. If we have a dispute, let's resolve it. Let me draw a line, cut my losses if I have to, and move on. And that's what will decide where I'm going to take my seat to. Because you may have your arbitrators, Nigerian arbitrators, yes, going to sit in London. The reason is the law, in the event that there are any issues, will be the law of the seat, the courts of the seat. So yes, the question is, why are you spending foreign exchange? Why can't they sit at the Hilton? Because after all, it's a private court. Because if any issues arise from that, you're going to be going to the Federal High Court or the court of the FCT. And quite frankly, if you're bringing in $100 million and I'm sitting advising you, I'm going to be telling you to go to London or go to Accra until we get dispute resolution in the courts, in a place where we can deal with it quickly and timelessly. It's no reflection on the judges. The Nigerian judiciary are some of the most hardworking that I know, are judicial officers. They're some of the most hardworking. They're working under so much pressure that I know about, that it's not fair on them either. But this is reality. And business does not operate on ideals. It operates on what is the reality and what are the circumstances that we're dealing with currently. So that's why we're still going out. We need to work together to ease the bottlenecks in the system, ensure that advocate to the head of court to have specialized commercial courts, as they do in Ghana. I took that to the first female Chief Justice of Nigeria when she was first appointed. And I took the statistics. And I said, well, why can't we have a commercial court? And bless her, her response was, well, the judges will get bored. We're doing the same thing over and over.
Can I put a different, can I add to that a little bit, yeah? Because also, when you're in-house doing these same agreements, right, there's several factors that drive where there's a distinction between your choice of law and your dispute resolution mechanism, right? Choice of law is the governing law of the contract. There are factors that drive what determines your choice of law. It's not always nationalistic. I'll give you an example. In instance where we have an international counterparty who is not a common law or a common law-based person like England or wherever, and we are common law in Nigeria, right? So sometimes we pick a third law, a third law of contract because we want to have some sort of call it fairness of contract, right? Sometimes we can even pick Nigerian law and choose a different dispute resolution mechanism. It doesn't have to be Nigerian law. You can have a separate choice of law for a document and have, you can even have the right to use English law for dispute resolution only, while the mechanical aspect of the contract remains Nigerian law. What that means is, even if you have to go to court in Nigeria, the court will have to summon some sort of expert on English law to advise it on what's supposed to do here, right? So, but in terms of business expediency, we also can go the ADR route, like Leonard Silka said. We can choose to use LCIA, arbitration and LCIA rules, and we can use them in Lagos. When you host your dispute resolution abroad, of course, you incur that location cost, but you can also have those rules applied here for you in Lagos under LCIA rules here, right? So there are evolution of these things over time. There's been so much, and I'm not going to argue for or against the popularity of Nigerian laws. I'm not going to go against that argument. I don't want to. But what I do is because we proceed with uncertainty in the beginning. We can both fall into risk and have to dispute. So in terms of the gentleman's question, the costs are modifiable by sometimes expert determination before dispute resolution, right? If your contract is technical in nature, you have the right, both of you have the right to appoint an expert to if the issues, in my business, most of our issues are technical. It is your land, it's not your land. Those are very minutiae, right? So again, business is unemotional. I would spend that $1 million to fly this guy from Slovenia to come and tell us who has this right than to pay lawyers 100,000 naira in Nigeria, right? So it's about the efficacy of business, fairness of business, and it's sometimes the cost, to the gentleman asked question, sometimes the cost is the way forward. And it's paradoxical, but sometimes businesses will choose a higher cost mechanism. You will think they'll take because they will know that this is faster. I can get this done in 2 days and move on my business. So the cost is not always the determinant of those clauses in our agreement. That's just my 2 cents.
Okay, thank you,
I
Mr.
wanted to just end on a positive note that all of these disputes involved international oil companies before, but it is changing.